So this is Diesel We the People News, and a couple of videos ago I talked about Cal Washington, and I've seen this and came across this. Now this video was about 3 years ago, and I thought, man, this is going to be perfect to give some people some ideas, the way what Cal Washington is going to be talking about on this Zoom thing come Tuesday of the 23rd, 2, 23, 22, so that way remind me later. Alright, so this is give you an idea what the debate's going to be about on Tuesday for whoever sees this video between here and there. Alright, because debate's going to be more along the lines as commercial liens versus legalese, and here we go.
Have the absolute authority to impose themselves on you and violate your rights. So let's get into it today, and we'll delve into all of the aspects of it. The problem arises because you don't have any rights. When you go to court, you want to get a jury trial to hear your complaint, and the fact is you never will if you're complaining about the government or corporations in general. The government's going to be against you. The judge works for the government, so he's going to be against you. And it's unlikely you'll ever see a jury. The jury's never going to hear your complaint, never going to see the evidence, and you're never going to get a judgment. So this approach is non-judicial. It goes around the judicial process and bypasses it completely. If you watch the shows on commercial lien, you'll see exactly what is going on when you listen to Lance talk about it, and we'll get into that later. So the first place to start on your journey to getting a notice of liability together is to get some background research and watch Josh Del Sol's video, his excellent video on Take Back Your Power 2017, and it's available to watch for free at Dr. McCullough's site. So you can go to see his must-see documentary, reveals dangers of the smart meters, and you can watch this for free. In it, about an hour and 20 minutes, you'll see all of the evils of the smart grid and why it's being implemented across the world in every country. They're trying to get this as like world domination, where they can spy on you and know everything that you're doing, and they'll probably be able to cut your power off without affecting any of your neighbors. They're going to know everything about you. The Stasi would have loved a system like this. I mean, anybody who's interested in police power, if you could listen in on everybody's conversation in their home, what a joy. Anyway, if you watch this show, you're going to see quite a bit of eye-opening, interesting facts. However, most people that are into it already have researched the smart meter. It's been around for quite a while now, so they probably know most of these things. But this is a very complete and well-documented expose on it. So you start here and watch the show. In fact, I would supply a copy of this video and use it as an exhibit, as evidence, and let them rebut and counter this information here, because they would have a hard time doing that. The next thing to do is to go on YouTube and type in Power Movement and go to their website this is Josh Del Sol and Cal Washington. And you can watch the Mass Action of Liability 2017. And in this show, they're going to go through how to use the notice of liability and what results they have gotten from using it. And the results they've gotten have been impressive. So it's inspirational to watch this, because it's always nice to see people getting results, as opposed to, you got 200,000 people marching in the street and the government doesn't really care one iota. Whereas if you can get somebody to quit their job, that's a big deal. Anyway, the Mass Action of Liability, and then after you've finished watching this, you can go onto their website and empowermovement.com and join up. And after you join, you'll be able to watch the second edition of this video series talking about how to implement the notice of liability. So you're going to have to get familiar with the terms and the instrument itself, and it's not worth doing unless you understand it. The next show I think it would be well worth your while to watch is the must-watch Commercial Liens show here by Liens. And he does a really good job of explaining the process and the reasons for doing the commercial liens. And the reason is that you just can't get any joy in a court, whereas you can get joy with a commercial lien. The notice of liability, in my opinion, is not truly a commercial lien. It's similar to the lien process, and you're going to claim that you have a right to do the lien based on a contract agreement, but at the same time, it's not strictly a commercial lien. But if you listen to Lance's explanation, he'll give you some extremely good pointers about doing it in such a way as to get good results. The idea with the commercial lien is that you send a notice in the beginning, which would be your administrative remedy, letting the other side know that you're stepping on my foot and I'm demanding that you get off. So you're telling them what the tort claim is and that you want them to pay you for the tort claim. And after 21 days, when they don't reply, that's their administrative remedy. Then you go into the affidavit of obligation. Once again, you're doing an affidavit and point by point outlining the harms that are being caused to you that are tort claims that you can get paid on, and then do a ledgering of the amount that each claim is worth and add it all up to a sum specific. Then he gets a solicitor, which is like a paralegal over there in England, I guess, to be the record keeper and show that there was no response done, and they issue a certificate of default that no response was in evidence. And then he goes to court and has the court recognize the process. And his claim is, the lien has no value unless it's in the public record. So unless you're putting it in court or at the county recorder or somewhere in the public record, the lien is worthless in the private. So here's Cal Washington doing his mass action and explaining how you're going to get the contract satisfied by tacit agreement. You're going to watch the show on YouTube that he has and enjoy what he has to say about it. There are 2 parts to this series. Only the first one is available on YouTube. So if you go on the website, empowermovement.com, you can download the template, which is the notice of liability. And it's a fill-in template, so you can just fill it in and then mail it off. And it has everything you need. You can add more people to the liability list and make changes if you want. But his position is that the template has to be used the way it is if you want his help in making sure you get what you want out of the situation. Most people's processes are really only perfected if you do it exactly the way they have it written. And, if you're competent to modify them, then, you can do whatever you want, but you're also responsible for doing whatever you want. So in this case, you're going to find out the people that are acting as the power supply company, the PUC, the Public Utilities Commission, the legislators that helped enact this stuff, and they're going to be the people that are going to be the recipients of your libel. They're going to be the libelees. So he calls hereinafter respondent libelees. They're going to be the ones that are liable for the damages that they're causing you by the installation of the smart grid and the smart meter. So he starts it off with a preamble, whereas it appears this and it appears that, and the only people that I know that do statements like this, whereas, are legislators. Most of the bills that you see are, whereas whereas the Bible is the Word of God. So anyway, he starts off with a bunch of whereas statements, and then he moves down to describing the restrictions that this contract are going to place on you. So the restriction of jurisdiction. Other than as expressly represented herein, you agree that no section of the contract shall be assumed to constitute a voluntary election by any of the parties thereto to submit the contract or the said parties to any venue of law, jurisdiction, court, or tribunal, other than by the agreement of the parties as stated hereunder. So you basically are telling the other party that they are not going to be able to take you to court on this, and a document will not be able to be reviewed by an agency or administrative tribunal or any court subject to the federal or state or political subdivision. So you're keeping the contract away from the purview of any other man, right? Basically, it's a deal between you and the people that you're sending it to. And when they sent you an offer, it was a deal between them and you. They didn't say, "Oh, you can take this to court." No, they just sent you a notice in the mail and said, "This is what's going to happen." And so this is just a counteroffer saying that, okay, I accept your offer based on this, and if you don't like it, you can remove your offer. And if you don't do anything, then you're going to be all bound up forever, because I'm going to tell you exactly what's going to happen to you if you don't rebut this. So we have the definition of contract from Black's Law, just so you know what a contract should be. An agreement between two or more parties, preliminary step in making of which is offered by one and acceptance by the other, in which minds of the parties meet and concur in the understanding of terms. And second, it is an agreement creating obligation in which there must be competent parties, subject matter, legal consideration, mutuality of agreement, and mutuality of obligation. An agreement must not be so vague or uncertain that terms are not ascertainable. So when you have a meeting of the minds, two parties that get together and bargain for something, they have to understand exactly what the bargain is for, right? Everything has to be spelled out so both parties are happy. If you think that you're buying something and the other person thinks they're selling something, but the thing that one person is selling and the other is buying are different things, then obviously you didn't have a meeting of the minds. And can you have two competent parties if one of the parties doesn't exist? That's the problem with all contracts. The state would have you believe are contracts, like a driver's license. A contract where there's two competent parties. How competent can the state of California be? I mean, they don't exist. They can't perform. They can't have an obligation that they can perform on. How are you going to have mutuality of obligation or agreement? How can there be an acceptance if the party that's doing the acceptance isn't real and doesn't exist? How is the party that doesn't exist going to have a meeting of the minds when it has no mind? So that's what a contract is supposed to be. And if you were buying lumber at the lumber yard, that's what the contract would be. It's only in fiction world where the contract doesn't comport to that. So under Bouvier's Law Dictionary, under maxims of law, consent makes the law. A contract is a law between the parties which can acquire force only by consent. Now, it's not a law between you and anybody else. It's only a law between you and the other party who are engaging in the contract. The contract becomes enforceable between you two, not enforceable outside of the two parties making the agreement. And it acquires force by consent. But there's a lot of definitions for consent. They use the definitions for consent against people when they say that you can actually consent by not saying anything. So here's the next definition: tacit, done or made in silence, implied or indicated but not actually expressed. So there's no written or verbal expression. Latches, estoppel by, a failure to do something which should be done, or to claim or enforce a right at a proper time So time is an element for laches. A neglect to do something which one should do, or to seek or enforce a right at a proper time. A species of equitable estoppel, or estoppel in by matter and pais. So estoppel is a bar. You're being estopped from proceeding at a later date because you waived your rights. It's the same thing as saying you're barred from making any complaint. You had your chance to complain, and after a certain period of time, you were barred from making that objection. You let it go. So when you say you have 30 days to respond, if you don't respond, you had your chance, and now you don't have it anymore. Neil he says nothing. This is the name of the judgment which must be taken as of course against a defendant who omits to plead or answer the plaintiff's declaration or complaint within the time limited. In some jurisdictions, it is otherwise known as judgment for want of a plea. So this is what happens in a court. If you put in a complaint in Federal Rules of Civil Procedure, you have 21 days to answer. If you don't answer, the other party can get a default judgment. And the default judgment is the most powerful judgment because there's no dispute. It's not like the jury's going to decide one person's facts are better than the other and they might have got it wrong. No, one party made the claim that you wronged me and the other party didn't object to it. They didn't put it in writing. They didn't say they didn't show a reason why they had a right to wrong you. So they defaulted on being able to make the claim. Acquiescence and laches are cognate but not equivalent terms. The former is a submission to or resting satisfied with an existing state of things, while laches implies a neglect to do that which the party ought to do for his own benefit or protection. Hence, laches may be evidence of acquiescence. Laches imports a merely passive assent, while acquiescence implies active assent. Like, are you okay if I go dancing with your girlfriend? If you don't say anything, then that's an active assent. So he who is silent is supposed to consent. The silence of a party implies his consent. You don't say anything, you must be okay with it. You implied the consent. And then he who is silent is considering as assenting when his interest is at stake. So when you grab your friend's car keys and you go, hey, I'm taking your car, and you're looking right at him and he doesn't say anything, if his interest is at stake, hey man, you can't take my car, I need it, or whatever. If he doesn't say anything, he must be okay with it. So there's an active assent there. And silence can only be equated with fraud, where there is a legal or moral duty to speak. Now, morals are, domain of religions. Thou shalt not steal, thou shalt not bear false witness. These are morals. If you don't have any religion and you don't believe in God, you may not have any morals. Silence can only be equated with fraud. An inquiry left unanswered would be intentionally misleading. We cannot condone this shocking conduct by the IRS. Our revenue system is based upon the good faith of the taxpayers, and the taxpayers should be able to expect the same from government in its enforcement and collection activities. This sort of deception will not be tolerated, and if this is the routine, it should be corrected immediately. Like asking them a question and them refusing to answer. See, they have a legal and moral duty to speak. If you say, I deny that I'm liable, and I don't see any constitutional authority you have to place a liability on me, and this is why, and they don't answer that, then they're just, deceiving you by failing to state any cause that you have a liability. So here we are with the notice of liability again. Guarantees and waivers of benefits. Guarantees for this instant action are the 1611 King James Bible, the coronation oath of Elizabeth Alexandra Mary Winter, the United States Constitution, the Bill of Rights, constitutional oaths of office, the common law, the law merchant, the Uniform Commercial Code, and case law. The claimant liabiliant does not claim any benefits of said guarantees. They're included because the public officials, through their oath of office, are limited by those guarantees. They're mandatory and
I have to pause that there for a second. Okay, we talked about deceiving us, right? Okay, Article 6, Title 4, Section 101, Oath of Office, that every government official has got to sign, and they have not done it. So they have taken other oaths, but they are supposed to take the constitutional oath first. Alright? And then they could take other oaths. But if they do not take the Article 6 Constitution, then they are deceiving you that they actually are in office. So anyone that has not taken this Article 6 oath of office, they're deceiving you, as they call themselves a government entity. So you can actually put the Article 6 in any type of paperwork and call it being deceived, because you have not filled out or shown verifiable proof of the Article 6 oath of office, which means all the judges are not judges. All the presidents we've had in the past few years are not presidents. All the Congress members are not Congress. We literally do not have a president, Senate, Congress, judges. Our country's blank. Just saying.
prohibitory on the oath taker, the public official. And all corporate officers are bound by the same restrictions that the agents of government are bound by, because all corporations are created as franchises by governments. They don't create themselves. They ask the government for permission to be a corporation, which grants them limited liability, so the people involved can't be sued. All they're trying to do is duck out of being responsible by forming a corporation. That's all it is. And for that privilege, the government gives them a privilege, but they can't give them something that the government itself doesn't have. So here at this website, they show the importance of the 1611 King James Version of the Bible. That King James Version of 1611 is what the Queen of England takes an oath of office on. In the United States, from George Washington to Barack Obama, each president has taken an oath on the King James Bible from 1611.
And just a reminder, this is 3 years ago, or plus. I can't remember how many, but it's been a couple of years for sure. So, Trump was taking this oath, and Biden just took this oath since then from King James. I say oath, but it's not the oath of office. They just put their hands on the Bible.
So now we have the notice. Response must be by the effective date. This is on the notice of liability, which is 14 days from the postmark date of this contract. I wouldn't use 14 days. It's too quick. It's do unto others as you'd have others do unto you. I don't like getting large pieces of documents that I'm going to have to pour through and respond to, and 2 weeks is not enough time for me. A month is reasonable. Response must be to the...
I agree with him. However, if anybody ever tells me that I got 10 or 12 days, whatever they tell me, that's the exact same date I'm going to tell them. They're not going to get a guaranteed 30 days. What are they trying to force upon me? I'm balance the books.
Postal locations of the two witnesses. Now here, this is a thing of beauty, because if you go to court, the court is the observer. They're just doing ministerial function. They're letting know the docket shows when a document got put in and if there was a response or not to that document. When you're using two notaries, or if you're using a notary, then the notary is going to be the honest person who's going to not be swayed by, and not an honorable person who's not going to lie for you. So they're going to say, I got a response, or I didn't get a response. But since you're not really trusted to not lie, if you have two people that aren't related to you, like, not your cousins or brothers or something like that, but two independent people, yeah, they're going to be a witness. And the definitive terms, what the Bible declares. So I like to use the New Testament, so if I can. So here you have Matthew 18:16. But if you will not hear thee, then take with thee one or two more, that in the mouth of two or three witnesses every word may be established. So that would be you and one more would be two witnesses, you and two more would be three witnesses. And, two witnesses that's not you would be able to establish the fact. Like, they say it happened, then it's not likely that they're going to be lying. So in order to find out the parties who you're going to send your notice of liability to, you're going to use the internet. It's pretty easy to do a search. And here's an example of searching for the members of the PUC, the Public Utilities Commission. If you keep looking, you end up finding what you're looking for, but you have to be pretty diligent about exhausting every little place that you can try to find things. Mostly you try to look for the contact us or about us section. But anyway, you look it up on the internet and keep searching until you find it. The other advice I'm going to give you is that when they give you a telephone number, oftentimes it's worthwhile calling them and ask the secretary or whoever answers if they have a fax number, an email account that you can email, the name of the person who's the CEO or the president, and the address, because maybe the address that they have on the website's not the current address that they're using. And if you don't have the right address, you're going to be mailing out your documents and they're just going to come back. And if they come back, well, then they didn't get them. The other thing you're going to want to do is, you notice how I highlighted the address and the telephone numbers and everything. You're going to create a Word document, just paste that information there, so when you want to go look for it later, it's easy to find. And then you can, just put all of the contact information and addresses and everything onto a Word document. Then you can keep that Word document with make a folder up on your desktop that's notice of liability for the power company or whatever, and put your Word document in there. So you can see with a little more searching, I came to this page about the CPUC, and it's got Michael Picker, who happens to be the president, and it also lists the other four members. So you need to get their information, the true name. So you can click on their bios and read who they are, and you're going to click it. You're going to send the NOL, and I would send it to like 2, 3, whatever members of the PUC, because they're responsible. And if you keep searching, who appointed them? How did they get into power? You find out that Governor Jerry Brown appointed them. In addition to that, you're going to claim that they're acting as respondeat superiors. So it's a maxim of law. The respondeat superior is the person in charge, the person who's responsible. If an agent acts and does something according to the wishes or policy of his superior, then the superior is responsible for his actions. That's the concept. Of course, if you go down to the bottom, you're going to say the doctrine does not apply in relation between state officers and their subordinates. Why not? Because the guy at the top wants to have no responsibility whatsoever. But of course, his agent is doing acts according to his policy, so he is responsible. So I've put in there that you're the respondeat superior. Another good thing to do is search the internet for information on smart meters. So here we have a ruling denying Marin jurisdiction to ban smart meters. And is that really the way it is? Well, no. If you look up Fred Kelly Grant on YouTube and his articles on coordination, if the local jurisdiction decides to enact an ordinance that smart meters are going to be banned, the state government and the federal government has to coordinate with them, and coordination means they have to obey them. They have to take the locals' rulings about what is going to be okay or not okay for acts within the geographical area that they have legislative authority over, and they have to abide by that. Look up Fred Kelly Grant coordination, and you'll see that the state has no power to overrule a local jurisdiction. So here's a little quick search for PG&E Corporation officers. You see that Geisha Williams, and I always like to get their full name, so upon a search I found that her middle name was Jimenez. Okay, so you use her full name if you can. She's the president, and the rest of them are directors. So interesting, you're going to use at least 2, 3, you could put everybody in there if you want, but you're going to serve your process on these people because they're the ones in charge. They're the directors, they're the president, they're the CEO, they're the chief financial officer. So then we go on the Secretary of State's website, and we look up Pacific Gas and Electric, and we call it's the corporate name, and we do a search for their business, because if they're a corporation doing business in the state, they have to have the authority of the state say that they can do business, and so they'll list them in there. And when you click on the name, you'll find that they have a registered agent for service and process. This is a person who, because the business is a fiction, they need to have somebody that you can mail legal documents to. So I generally tend to go, okay, I'm going to send it to the person, care of the corporation, care of the registered agent for service of process. And even though this is not technically service of process, at least they wouldn't be able to argue that you never properly served them, because you did. And then when you look at all of their little filings here, it's kind of interesting. And here, let's look at PG&E, which is a publicly supported monopoly, because that's what it is, a monopoly. They gave PG&E the right to put their products on government-owned roads through easements and supply electricity for the benefit of the people, and the PUC was there to control them and say what they could charge and what they couldn't charge. But let's just look at the amount of money these guys are making. It's unbelievable. So this document shown here is filed by the state of California, by PG&E with the state of California on May 24th, 2017, and it shows what they were paid last year, these executive officers and directors. Anthony Early was paid $11,730,000. That's not bad for a year, huh? He's got 137,000 shares of a publicly supported monopoly. PG&E is a monopoly. They had easements to put their product on the streets that were given to them, no doubt, for free. How about all these other people? Jason Wells, over $3 million. Edward Halpin, almost $3 million. John Simon, almost $3 million. Hoon Park, almost $3 million. Dinar Mystery,